Hello everyone, I'm Dr. Kalpana. Today we are going to discuss about standard form contracts, which are standard form of contracts are widely used in today's world because companies like LIC, railways, and other companies which are selling their financial products uh, have the printed form of contracts where customer do not have choice to alter the conditions of that contract. So, but sometimes this may lead to unfair terms for individuals, and person who is signing these forms does not have a choice except signing it, and most of the time they even do not read them also. But the question is how to solve such problems which are arising out of signing these kind of forms where one party is at loss and other party is absolutely at benefit. So now question is what is called a standard form contract. So fundamental principle of law of contract face problem in the present time due to large scale and widespread practice of concluding contracts in standard forms. For example, life insurance company issues thousands of insurance cover every day. Railway has to make innumerable contracts of carriage, and it is difficult, rather impossible task to make separate agreement for everyone when it comes to an offer made by such kind of companies. Therefore, they keep printed standard forms. So once Lord Denning pointed out, made an observation in Thornton versus Shoe Lane Parking Limited case, no consumer in the thousand ever read the condition. If he had stopped to do so, he would have missed the train or boat. That is the observation made by Lord Denning in Thornton versus Shoe Lane parking case, which signify that most of the times terms and conditions are written in such a manner it is difficult to read them out. So people, instead of reading them, they go by signing it. For example, if you go to the bank and opening your bank account, we hardly read any terms and condition, but just we need an account in the bank and we sign the form wherever the person who is handling us as customer is asking to sign, and we sign in the box of signature. So this gives unique opportunity to these companies the weakness of individuals by imposing upon their terms which look like kind private legislation and may go to the extent of exempting the company from all liability sometime, and court find it very difficult to protect weaker party in such cases, particularly where the person has signed the document. And most of the time when you sign a document in civil kind of contractual relationship, it is binding upon the person who has accepted it. So in such cases, court have constraint to hold that he will be bound by the document even if he never acquainted himself with its term, or even the person signed without reading it. So that is not the defense in law of contract. If person was not knowing and sign the document without reading the condition, it is the problem of that uh, party to the contract. So there was one rule which was propounded in L. Strange versus Grokop. So Mrs. L signed an agreement without reading it, under which she bought a cigarette vending machine. Agreement excluded liability for all kinds of defect in the machine, and machine was defective. Court found it as a fact that supplier had made no effort to bring that sweeping exemption term to the notice of Mrs. L. Even then, though it's kind of unfair, when a person is buying a machine, it should be working at least for some time. If machine has been delivered to the customer, which is defective, it sounds unreasonable, but still court held where document containing a contractual term is signed, then in absence of fraud, misrepresentation, party signing it is bound and it's wholly immaterial whether he has read the document or not. So here the importance of signature on a document is very significant. So such contract are various described as a contract of adhesion, which means individual has no choice but to accept. He does not negotiate but merely adheres. So compulsory contracts, they being a king of imposition and private legislation. Now, in order to protect the weaker party in such kind of standard form contract, courts have evolved certain protective measures to protect certain in certain cases, and how to interpret and construe such kind of contract where one party at loss or a weak party is at loss. So individual therefore deserves to be protected against possibility of exploitation which may be inherent in such contracts. So first protective measure and principle has been applied by the court, reasonable notice. So in the first place of the duty of a person who is delivering a document to give adequate notice to the offeree of printed terms and conditions. Where this is not done, acceptor will not be bound by the terms. This rule was laid down by House of Lords in Henderson versus Stevenson. This is a landmark judgment where this rule was propounded by House of Lords. So fact sheet of this case is like this. Plaintiff bought a steamer ticket on the face of it, which were these words, Dublin to Whitehaven. On back were print certain conditions, one of which excluded liability of company for loss, injury, or delay to the passenger and his luggage. Plaintiff did not see the back of the ticket, nor was any indication on the face of about condition written on the back, which means the plaintiff did not know whether something is written on the back of the ticket. The plaintiff luggage was lost in the shipwreck caused by the fault of the company servant, and he was entitled to recover the loss from the company in spite of exemption clause. Because on the face of it, he was not communicated about printed exemption clause reasonably by the company. So court ruled in favor of the plaintiff even if they had printed exemption clause on the ticket itself. There is another case which is Parker versus Southeastern Railway, which comes from 19th century. The plaintiff deposited his bag at clock room at railway station and received a ticket. On the face of the ticket were printed, among other things, the word "see back." And on back there was notice, company will not be responsible for any package exceeding the value of £10. And a notice to the same effect was also hung up in the clock room. And plaintiff's bag lost, and he claimed the full value, the bag which was more than £10. The company relied upon exemption clause. The court held that there was no proper notice to the plaintiff as he did not see that conditions are written on the back of the ticket. He received the folded ticket, and where C was written was obliterated by stamp in red ink, which means it was not readable. Second principle applied by the court, notice should be contemporaneous with contract. Means the time of the notice is very significant when it comes to protecting the right of the weaker party in standard form contracts. So notice should be given before or at the time of contract. A subsequent notification will amount to modification of original contract and will not be bind other party unless he has assented thereto. There is famous case Orley versus Marlborough Court Limited. A husband and wife hired a room in a hotel and paid a week rent in advance. And when they checked in the room, there was a notice on the wall: proprietors will not be responsible for article lost or stolen unless handed over to the manager for custody. Their property was stolen and defendants were here held liable. The court said notice was not the part of the agreement. So subsequent finding that notice when they checked into the hotel was not considered the part of the contract. So they were able to recover the loss from the hotel. Theory of fundamental breach, which is very, very important to understand. Even if there is exemption clause, if there is a fundamental breach, what is fundamental breach? It is a method of controlling unreasonable consequences of wide sweeping exemption clause, even when there is adequate notice of the terms and condition in the document is given. What constitutes fundamental breach? Every contract contains a core or fundamental obligation which must be performed. If any party fails to perform that fundamental obligation, he will be guilty of breach of contract, whether or not any exemption clause is inserted which purports to protect him. In case of Davies versus Collins, plaintiff entrusted the dyer and cleaner a uniform for cleaning. On the docket given to him when he handed over the uniform were following clauses: whilst every care is exercised in cleansing and dyeing the garment, all orders are accepted at the risk of owner. We are not we are unable to hold ourselves responsible for damage. So in this case, even if there was exemption clause, but there is a fundamental breach of an obligation, they are required to safely return that clean uniform. Strict construction. When it comes to any court comes across any case where there is a problem to understand what went wrong in a contract, exemption clauses are construed strictly because most of the companies, by putting an exemption clause, are trying to save themselves in case of any dispute arising out of that contract. So particularly when a clause is so widely expressed as sound highly unreasonable. In case of any ambiguity in exemption clause, usually such clause is construed in favor of the weaker party, as court are practicing. So Supreme Court in case of National Fertilizer Limited versus Puran Chandangia held that power to vary terms relating to the quantum cannot be unlimited. So any clause giving absolute power to one party to modify the contract terms would amount to interfering with the integrity of contract. So meaning thereby, if there is an original contract and there is a conflict between exemption clause, which is interfering with it substantially and giving the power to one party and weaker party is here not to negotiate on it, then court are in favor of weaker party by strictly construing the exemption clause. We are here clearly talking about exemption clause where standard forms are keeping them. Liability in tort, though law of tort is not much in practice in India, but in England, whenever there are contractual breaches, but law of tort is still there to save a person whenever there is found negligence on the part of the defendant. So even though an exemption clause is exhaustive enough to exclude all kind of liability under contract, it may not exclude liability in tort. So in White versus John Warwick, the plaintiff hired a cycle from the defendant and defendant agreed to maintain a cycle in working order And a clause in agreement provided nothing in this agreement shall render the owner liable for any personal injury. So while plaintiff was riding the cycle, saddle tilted forward and he was thrown and got injured. It was held that though clause exempted the defendant from liability, contractual liability, it is open to the parties to exclude liability even for negligence. Unreasonable term is the sixth uh, parameter, or you can say uh, principle applied by the court to protect the weaker party in a standard form contracts. So another mode of protection is to exclude unreasonable terms from the contract. A term is unreasonable if it would defeat the very purpose of that contract, if it is repugnant to the public policy, which is a big wide, vague term. Anything which is in violation of public policy, that contract would stand cancelled because public policy is on priority. Nothing private agreement can be against public policy. So in case of Lily White versus Manu Swami, a laundry receipt contained a condition that customer would be entitled to claim only 15% of the market price or value of the item in case of the loss. The plaintiff's new sari was lost. Court held that such terms are as unreasonable and is not in public interest. So today's takeaways: standard form contract present a significant legal challenge requiring careful consideration for the balance between efficiency and fairness. And court are increasingly willing to protect individuals from unfair terms, but it is crucial for individuals to understand their rights and responsibilities when signing such contracts. Though there is a notification most of the time when you are buying mutual fund or LIC policy, read the terms and conditions carefully, and warnings are also being written there. Then also sometime when it comes to dispute uh, arises, then such kind of things come across all your way. So with this, I would end here. Happy learning. Thank you so much. Have a good day.